So who are we doing now?
This is Mr. Briegel Sanders.
Okay. There we go. All right, now calling the matter of Briegel, State of Georgia versus Briegel Sanders, charged in warrant number 2024 WA 04016, battery, 2024 WA 04017, affray, 2024 WA 04018, riot in a penal institution. Representing the state is Attorney Freeman, representing the defendants, Attorney Rogers. Your witness, Attorney Freeman.
Thank you, Your Honor. Deputy King, would you raise your right hand, please?
Yes, ma'am.
Do you swear and affirm that the testimony you're about to provide in the matter of State of Georgia versus Briegel Sanders will be the truth and nothing but the truth to help you God?
I do.
You can lower your hand. Please tell us your name and how you're employed.
I'm Deputy Sheriff Daniel King and employed with the Clayton County Sheriff's Office.
How long have you worked with the Clayton County Sheriff's Office?
I've been with the Sheriff's Office for approximately 7 months, and before this, I have 6 years as a police officer.
Sir, were you working with the Clayton County Sheriff's Office on May 12th of 2024?
Yes, ma'am, I was.
On that particular day, did you come into contact with inmate Briegel Sanders, while incarcerated in the Clayton County Jail?
Yes, ma'am, I did.
Tell us what brought about on this particular day your contact with Mr. Sanders?
I was assigned to our attack patrol unit with a detail assignment inside the jail. A part of that was assisting the jail with operations. I was notified of an altercation that had occurred. Originally, it came out as a possible stabbing between 2 inmates in housing unit 7, section 1. I went down, looked at one of the involved parties, which was Mr. Sanders, and then went back and determined the time frame after speaking with the correctional officer in charge of that housing unit. Went back and viewed CCTV footage of the incident and observed both Mr. Sanders and Mr. Pless in a physical altercation in housing unit 7, right in front of door 103, which is on the bottom floor, and it moved over to the stairs. After speaking with both parties and looking at both evidence, there was no probable cause to take charges out for both.
Deputy King, when you reviewed the video, were you able to determine, who started the fight?
No, ma'am. The altercation originally ensued inside the cell and then moved outside the cell. Both parties, Mr. Pless and Mr. Sanders, weren't necessarily being cooperative with telling us who started the fight. And as such, based off the evidence I had at hand, both were charged with the same charges.
Are you saying Press or Plus for the victim in this case?
It's a victor-offender kind of relationship. So the victim is the offender is the victim. The other involved party would probably be the better way to state it. Last name is Pless, Pless. First name is Walter.
Regarding Mr. Pless, did he have visible injuries?
Yes, ma'am, he did have visible injuries.
What injuries did he have?
He had scratches and lumps and contusions and bruising on his head.
Did Mr. Sanders have any visible injuries?
Yes, Mr. Sanders had a laceration above his eye and several scratches and bruising and lumps as well.
Were you able to speak to any other witnesses who may have seen what happened?
I was not able to speak to any other witnesses as they were the only 2 inside the cell. I did speak to the correctional officer that was in charge of the housing unit, Officer Bulletary. He was the one who notified his supervision of the fight. He also briefed me on what he observed, and then I also was able to watch back the CCTV video of the fight itself.
Did the fight make its way outside of the cell?
Yes, ma'am. It made its way into the day room or a common area.
Did any other inmates?
Were other inmates.
And that's what I was saying. Were there other inmates into the area where they brought the fight into?
Yes. Yes, ma'am. There were several other inmates within the area.
Did any other inmates become involved in the fight?
No, ma'am. No other inmates got involved into the fight.
Did all of this happen in Clayton County?
Yes, ma'am.
How did the fight break up?
I believe the fight dissipated. I can't recall. I don't want to speak out of context. I can't recall how the fight broke up, but I know it did break up. It was prior to officer intervention.
Prior to this fight happening, was there any other disturbance going on in that particular area of the jail?
No, ma'am, there was not. It was I believe the time that this occurred was around, if I have it here. It was around 2 o'clock in the morning, so it was what's kind of known as quiet time within the jail, where everybody's just kind of relaxed, chilled out. If they're not within their cell asleep, they're in the day room watching TV on their tablets, or just trying to enjoy the tranquility of that nighttime.
Thank you. No further questions.
All right, Ross?
Thank you. So Deputy King, if I understand correctly, I think you said you were, I guess, kind of assigned to like a detail at the jail or something. Is that what was going on?
Yes, sir. Yes, sir.
And so are you familiar with either one of the parties other than from this incident?
I've had contact with them during cell checks or during other functions inside the jail,
Okay, so you're
but
regularly
nothing notable.
Yeah, so that's what I was kind of trying to get clear. So you are regularly at the jail, though, and as far as in the
Yes, sir.
jail.
Yes, sir. Yes, sir. Part of the sheriff's office.
And if I understand correctly, nobody else is. Well, let me back up. You said it was around the quiet time, but that there were people in the day room also still.
Correct.
Okay. But nobody else is charged other than Mr. Pless and Mr. Sanders. Those are the only two charged about this incident.
Correct, because they're the only two involved in the physical altercation.
And if I understand correctly, you have each listed as a victim and an offender in the situation, or at least that's how you conceive of them.
Yes, sir. That's the way NIBRS places it when you have a victim and offender having the same charges involved in the same incident.
But and part of the reason, well, let me ask if I understood you correctly on direct. Part of the reason that you charged them both is because neither side was saying much about the fight. Is that correct?
Correct. There wasn't in this instance, it doesn't fall under domestic violence, so that's necessarily a primary aggressor function. But both parties both had injuries, visible injuries, falling under 16-523-1 for battery. Both participated in a physical altercation or fight within a public place, and both committed a violent act within a penal institution, therefore classifying them for all three of those charges.
But you don't, at this point, seeing based on the information that, if I understand it correctly, the video does not show the start of the fight, correct?
The video does not show the start of the fight, correct.
And so at this point, you don't know who threw the first blow or if it was an arranged fight, or you don't know how the fight started at all. Is that correct?
A range fight or not, a fight is still violating code section.
Yeah,
and whoever threw the first blow. Yes, sir, I'm answering your question. Whoever threw the first punch, I gave them the opportunity.
Do you know?
Go ahead, sir.
Do you know who threw the first punch? Is what I'm asking.
Yes, sir. And like I was trying to say, nobody told me who threw the first punch. Nobody wanted to say that.
And your attempts to speak with each person, are they recorded in any way?
Yes, sir.
And did anybody write any statements, or is it just like a body cam recording we're talking about?
There's going to be body cam videos and photos as well of the injuries.
But there's no written statement or anything?
It's not normal procedure to have a written statement during incidents like this.
Okay. So is there a written statement or not?
I believe I just answered your question.
You didn't. You told me what the procedure
Deputy,
was.
just answer yes or no, please.
No. Well, they're not from the involved parties. There's a written statement from the officer who's working the tower.
And that officer, they didn't see how it started either.
It started inside a cell.
Right. I said the officer did not see how it started either.
It's I feel like it started inside the cell. Are you saying that the officer see what happened inside the cell?
Right.
No, he did not.
No further questions at this time.
All right, any redirect?
No, Your Honor, the state rests.
Any closing arguments?
State waives opening.
Go ahead, Attorney Rogers.
Thank you. Judge, at this point, we don't know if Mr. Sanders is acting in self-defense or not. There's no indication that anybody knows how the fight started. Both people are considered, I guess, offenders and victims in the situation. And part of, from what I can gather, the basis of the charges is strictly because there's a fight on video at the jail, and because I guess nobody would tell on somebody or whatever that that law enforcement was looking for them to do. The fact that you won't tell on somebody is not a basis to charge you with a crime. That doesn't cut one way or the other as far as evidence goes, especially at the jail where people are, concerned about their safety for cooperating with the law enforcement or anything like that. So the fact that somebody doesn't risk their long-term safety or further jeopardize their long-term safety is not a basis to charge them with a crime. And like I said, at this point, you don't know who threw the first punch. If there's a person who throws a first punch and another person is defending themselves, and you don't have a basis to say one way or the other that Mr. Sanders is not defending himself, so that's what we're here for today. It's premature to charge this as a battery because that would imply that it was not justified. And the same thing with an affray. If it's not voluntary, you're not willingly engaging. If somebody attacks you and you fight back, that does not make you a criminal. It does not subject you to charges just because someone attacks you and you fight back. Same thing would apply for acts of violence in the jail. And I want to double check, but I believe this is charged under 161056. It would have to be an unlawful act of violence. As has once been said, it's just a paraphrase of a statement. When it's self-defense, I wouldn't even consider it violence. It's self-preservation. And so at this point, since you have no basis to say that Mr. Sanders started this fight and that at least part of the basis of the charges is that Mr. Sanders refused to tell or do what the government wanted him to do, I would say that's insufficient, and I would ask that the charges be dismissed for lack of probable cause. Thank you.
All right. Attorney Freeman.
Thank you, Judge. We're asking that all the charges are bound over to Superior Court, whether or not Mr. Sanders has a self-defense claim is something that should be argued in Superior Court, not at the probable cause stage. At this stage, what the testimony shows is that he was involved in a fight. He struck the victim in the case who had visible injuries, and he participated in unlawful acts of violence in a penal institution. Those are the things that the testimony indicates. And so given that, we are asking that all three charges are bound over to Superior Court.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind all three cases over to the Superior Court of Clayton County. That's the order of the court.
Thank you, Judge. And may Deputy King be excused?
Yes, thank you, Deputy.
Thank you, Deputy.
Thank you, guys. You guys have a good one.
All right, have a good one.
All right, who are we doing next? Hold tight 1 second, but you can go ahead and tell me who we're doing next.
Bush.
Bush, all righty, hold tight.
Give me a second, Judge.
7:20 p.m. One notification. Messages. Now.
Judge, if you would, or anyone assisting a judge, put me into a breakout room with the jail. I need to have a conversation with Mr. Bush.
Judge stepped away. She'll be back shortly. She didn't make me the co-host, so I can't move you in there.
Man, we need to get on her about that. All right, I'll wait.
Thank you.
All right, my apologies that I had to deal with an emergency. I am back. My apologies.
No.
Attorney Lewis, my apologies. I heard you talking about me.
Yeah, I did, Judge, but I would never talk behind your back, only to your face. Give that young lady some authority, Judge, when you leave.
Okay.
Okay.
I'll think about that. You know,
Okay.
she's already bossy, so I don't know if I want to do that.
I understand. Judge, can you
Okay.
stick me in with the jail so I can communicate a new offer to my client, Mr. Bush?
Okay. So you can just join too, and the deputies can join too. You're already there.
Okay, thank you,
And
Judge.
then who do we have? Now, what about, so Kevin Carpenter, I'm getting him evaluated tomorrow, so we can continue that to 7:10. We're setting up for him to get evaluated. And then, Christopher Davis, I know that the officer was on leave, right? All right, so Christopher Davis, Attorney Rogers.
Yes, ma'am.
All right, so how many times has this one been continued? Christopher Davis?
It's been continued a few times, Your Honor. It's hard for me to put a number on it. I know some of them just can't. Some of them were on our request. So
Okay.
yeah, I couldn't put a number.
Okay, I'm gonna do one final continuance to 7:10. And I'm putting final continuance on that. So if the officer is not available, then that case is gonna be dismissed.
Thank you, Judge.
And then what about Johnson? We still have to do Johnson, right? Adrian?
Attorney Lewis is in the breakout.
Oh, okay.
He's the one for Johnson.
Mhm, mhm, mhm. Okay, and so Attorney Freeman, what do you have as having being left?
I'm sorry, Judge. I was saying that regarding Johnson, I haven't had a chance to try to reach out to the officer. He is not already on, and so I don't know if I'll have that officer or not. But I know we have Simeon Bush,
That's
and
what I
then
was about to say.
and that's it.
All right, so that's what we're gonna do next, Bush?
Yes, and that's the one when Attorney Lewis is in talking with his client.
Oh, okay. All right, I'm sitting right here.
Okay, and I'm going to see what I can do to try to get the officer on Johnson, because
Right.
that's why I haven't had a moment to try to do that.
Okay, all right.